Hello, everyone. Welcome to this program, Avoiding Discipline at the USPTO. To send a question to the presenter, type in the box below the participation tab. Materials for this course can be downloaded from your supplements tab. Finally, we encourage everyone to take a few brief moments following the presentation to complete a brief survey. That link can be accessed under your viewer window. It is my distinct pleasure now to introduce our presenter for this program, Emil Ali. Emil, the floor is all yours.
Thank you so much. So again, my name is Emil. A little bit about me. I am a registered patent attorney with a focus on the intersection of IP and ethics matters. Today, I'm going to be talking about how to avoid discipline or sanctions at the USPTO. It's going to be an ethics presentation mostly geared towards IP lawyers, so mostly patent prosecutors and trademark prosecutors with some discussion about some litigation-related actions as well. I would hope to keep this as an interactive presentation, so feel free to send any questions you might have in the chat. But with that, I'll talk about a couple areas I'd like to focus on today. So we're going to go over the regulatory power of the USPTO. A lot of attorneys or even patent agents that I speak with don't know much about this power. They don't know sometimes until it's too late. So we'll talk about how the USPTO regulates attorney conduct or practitioner conduct. We'll also talk about that office within the USPTO called the Office of Enrollment and Discipline. We'll talk about working with foreign associates. With all this stuff about tariffs and all that, we know that we're in a globalized economy. But how do we as practitioners work with other practitioners abroad? And how do those folks work with us to help clients? We'll also talk about candor obligations and inequitable conduct, right? Our duty to be honest and forthright with the USPTO. We'll talk about conflicts, and if we have some time, we'll go into the use of AI. So throughout this presentation, when I do talk about, ethics issues, generally I'm going to be referring to either the ABA Model Rules of Professional Conduct or the USPTO Rules of Professional Conduct. So with that, let's talk about what practice before the USPTO is. And I realize that this may be a little bit basic for some people, and it may just go over a lot of people's heads, but I want you to think about it for a second. When we are in a state and we're practicing law as, for example, a lawyer, we know that practicing law in a jurisdiction where we are not admitted could be against the professional conduct rules in that state, right? So I'm barred in a bunch of jurisdictions, but I am not barred in Nevada. If I go set up shop in Nevada and start offering, family law services, I would probably be violating the ethics rules in Nevada because it's a state law issue and, it's a physical issue in terms of the states tend to regulate practice within their borders. On the flip side, at the USPTO, there is no physicality. Whether you're practicing from California, Nevada, Mexico, or Timbuktu, if you are engaging in practice before the USPTO, you are subject to their rules and subject to any of their restrictions that they have. Well, 11.5 of 37 CFR actually talks about it's more than just the physical practice or actions before the USPTO. Giving advice in contemplation of filing a patent application, giving advice in contemplation of filing a trademark application, giving any sort of service that comprehends any matter connected to a presentation of a paper before the office, including filing a FOIA request, could subject you to the USPTO's jurisdiction. And this is important because with most federal agencies, we're allowed to practice before them based upon the Administrative Procedure Act. So the reason that you can represent your, friend before the Social Security Administration or before the IRS or, before any alphabet soup agency is the APA. And that's generally how you practice before the trademark side of the office as well. But the patent side of the office is very unique. So they have statutory authority at the USPTO to allow the regulation of attorneys and agents before it and to do moral character. That's this area right here, 35 USC 2B 2D. What's not listed on this slide is 35 USC 32, which also gives them statutory authority to discipline those who practice before it. And that's actually very interesting because a lot of people have made the contention, well, if you have special rules to discipline or to register patent practitioners, why do you have special rules? Why do you interpret that to also discipline trademark practitioners? And that's important for those of you that may be solely trademark practitioners. You may not realize this, but the USPTO has been very aggressive in terms of going after trademark practitioners. And those cases probably make up about 50% of the disciplinary actions that are coming out of the USPTO right now. So what's important for you to know? The USPTO rules are very similar to the ABA model rules, but in some ways can be somewhat more permissive. But what rules apply? Is it just the USPTO rules? And the answer to that is no. Generally speaking, the rules that apply are those where the predominant effect is. And there's an analysis under ABA Model Rule 8.5 that's traditionally done. But here, there is no field preemption. If there's something that, for example, your state bar does not permit you to do, generally that's okay. They can not permit you to do something. However, if it conflicts with your ability to practice before the USPTO, then there may be conflict preemption. So because of that conflict, there may be a way that the USPTO rules are just kind of preempting that sole issue just to protect the ability to practice for the USPTO. And that's what a case called Sperry v. Florida talks about. Kroll v. Finnerty was an argument made by Michael Kroll, who basically said, only the USPTO can discipline me, not New York. And that was found not to be accurate. So let's talk about the big bad OED. So OED used to actually be called the Office of Enrollment and Disbarment. And then many years ago, they changed their name to the Office of Enrollment and Discipline. They are responsible for a lot of different things, whether it's the pro bono program, law school certification, enrollment, moral character issues, and of course, disciplinary matters. I worked there for a number of years, and it's a very interesting office, a little over 20 attorneys, probably around 20 support staff, and it's grown significantly. It has, a lot of people have impressions of the office based upon their interactions with them. And I think, every situation is different. Obviously, they do some happy work, which is registering people as patent lawyers. And then they do some pretty sad work, which is dealing with folks that maybe have gone off the deep end, have drug and alcohol issues, and they're facing some sort of suspension or exclusion / disbarment. It's just helpful to know that OED is, a group of lawyers. Many of them are not actually patent lawyers or trademark lawyers, but they focus their practice really on investigating and prosecuting lawyers. So let's jump into the actual substance of some of the topics we want to talk about. So one very common question I get is, are we allowed to work with third parties? And before we get into the foreign associate aspect of it, I want you to think for a second back in, what would that be, the late 2000s, 2007, 8, and 9. We had an economic downturn. And so from the zero interest rates, we saw interest rates getting adjusted, people doing mortgage modifications, things like that. And we saw a lot of folks advertising on TV saying, we can get you a mortgage modification. And what it was is you would see somebody on TV, you'd pay that company $2,000. And then a lawyer would then have to call the mortgage company and try to modify the mortgage. And you would pay them the company $2,000, but the lawyer might get $100, $200. The lawyer may actually never talk to the client. When I put an example like that in the forefront, everyone's like, well, that sounds unethical. Why is the lawyer allowing a company that's owned by non-lawyers to sell legal services? And why are they allowing themselves to only make $100 or $200? That's, very, very low. You think about it from that perspective. But then we look at foreign associates. How is that any different? And another example would be invention promotion companies, et cetera. Foreign associates, though, are different. Not necessarily under the ABA ethics rules and general state practice, but under the USPTO's determination about this. And think about it this way. If I wanted to get patent protection in a foreign country, I don't speak maybe Japanese, and how would I be able to apply for a patent application there? So would my client then have to reach out to somebody who may not be familiar with, communication styles here? No, generally speaking, the U.S. Client will hire the U.S. attorney who may contract with attorneys in various jurisdictions. Same thing in reverse. So foreign associates for us are some sort of foreign representative. They could be a lawyer. They could be a patent agent. They could be anything. They could be also a non-lawyer. And they're somebody that's going to be a kind of a communication conduit for us. They're going to be able to talk to the client for us, or we would be able to talk to the client for them, and vice versa. So in my experience, I would say around the country, probably or around the world, probably 25 to 30% foreign associates that my clients who are lawyers and law firms deal with are non-lawyers. They may be, patent agents, trademark agents, et cetera, but it is a very, very common issue. So I don't have it on the slide here, but there are some official Gazette notices, so sub-regulatory guidance from the USPTO that basically explains that this is not only very common, but it is okay. There are some things that you should do to make sure that you're, let's call it the mutual client. So let's say we're representing somebody from Japan. Let's say it's Sony. So a law firm in Japan comes to you and says, we would like to have you file on behalf of Sony a trademark application in the US. Normally, I would say, well, I want to talk to the actual client or the client, representative. In this case, they say, no, you have to talk to us. Is that okay? And the answer is generally it's okay as long as you have a reasonable basis to, one, believe the contentions made in the document, but two, that you have a reasonable basis that Sony knows who you are. Sony has authorized this sort of conduct. So this is something, again, very, very common, but there are some best practices that you should consider. So let's start with a quick hypo about foreign associate practice. So Shenzhen IP Services contracts you, a US licensed lawyer, to file 100 trademark applications and 5 IPRs before the USPTO on behalf of their clients. So they provide you with everything you need to file. They've already done the work. All you do is review, sign. They've even told you who the RPI is and given you the proof of use specimens. Everything is laid out for you. This is just amazing. So who is the client? Is it Shenzhen IP Services? Or is it each of their clients? The IPR folks, the trademark applicants? Who is the client? Well, to be clear, this is a client representative. This is not your client. Your communications with this party hopefully would be subject to privilege, but it's because they are authorized representatives of these applicants and these folks that are engaged in the IPR practice. So what steps should we take prior to signing and filing these documents? Well, that's a loaded question. We want to make sure that we have a reasonable basis to do things. So when it says the specimens are ready to go, just because somebody says this is a good specimen, does Shenzhen IP Services know what a good specimen is? Maybe they've filed a lot of trademark applications through US associates. They know. But maybe the applicant doesn't know. Maybe they haven't reviewed it well enough. So I want you to think for a second. When you sign or file something, how do you feel comfortable with it, right? If they use ChatGPT to create these documents, would you feel comfortable signing an IPR saying that you're filing this based upon X, Y, and Z? And then what steps should you take after the filing? So let's think for a second. So is client consent necessary if you file these applications on behalf of a party? So what if, let's just say this was a patent application and you wanted to get microentity status. Do you need to talk to the client? How do you know how much the fees that you're charging to Shenzhen are being marked up? right? Is it being billed to the foreign associate and paid by the foreign associate? Is it billed to the foreign associate being paid by the client? Is it billed to the client being paid by the client? Those are all really important considerations. So one point to also make is how much information and advice do you provide to the foreign associate when seeking direction or trying to get instructions? And as US licensed counsel, the one whose license is on the line, how do you deal with disagreements with the instructions? So, for example, maybe they want to maybe they have arguments they want to advance that you don't believe in. There's some claim language or structure issues. Those are all really important considerations. And honestly, I can't answer those with one fell swoop and say this is how you should do it. But these are important considerations for you to think about. I'm not saying don't engage in foreign associate practice, but understand who your client is and what steps you need to do to make sure that you feel comfortable with that relationship. So as I mentioned to you, there's some OG notices, and here's the citations here. It basically says, and this is one small piece of the pie, you can rely upon the advice of a corporate liaison, right, non-attorney, or the client applicant's foreign agent, again, doesn't have to be an attorney, as to the action being taken, as long as you are aware that the applicant has consented after full disclosure to being represented by that liaison or foreign agent. So they should know who you are, and they should make it clear to you that they feel comfortable using this specific agent, non-lawyer otherwise. So what's another part of this that people often forget, though? The USPTO, in that same OG notice, said you should consider, it's not required, but consider adding what I call a permission slip. The undersigned, meaning the applicant, authorizes the U.S. attorney or agent named herein to accept and follow instructions from the foreign associate or liaison. Again, not saying this is required. Many times OED says this is required. It is not required. It's just a good idea. It is something that most people don't do. It's a suggestion that's not followed, only because people probably have not read this official Gazette notice. So if you pull one thing out of this foreign associate conversation, you should consider having this, and a couple other points, which I'll make in a moment. So I like to see some sort of engagement agreement with a client. Why is this very important? I know it's not very common, but I ask that you think about it. Even if it's not completely signed, if it at least says something like, here are the terms and conditions, at least it could be helpful for you, because we want to know, how long are you going to be representing this person for? Are you going to be doing renewals on the trademark side, maintenance on the patent side? What are the expectations of the scope of representation? What are the fees? Are you limiting the scope? Maybe there's an advanced conflict waiver. And in general, you could have a separate agreement with a foreign associate, but it could just be what I like to call like a playback. A playback would be, dear foreign associate, thank you so much for asking us to represent our mutual client, Sony. And then attached, please find a, engagement letter for Sony. And all it is, dear Sony, you've authorized such and such foreign associate to represent your interests. Here's the scope of representation. Here are the fees. Here's the timeline. That's it. Something as simple as that. No signature required. That would be a very, very good idea. So we're about a quarter away through the presentation, and I just need to read something to you. In order to comply with New York regulations, attorneys looking for CLE credit in New York will need to be able to provide a code. This code is not intended for the audience live or on demand. I'm not sure what that means, but I will read the code twice and only twice, and cannot repeat it or email it to you. So please take note of it. The New York State code number is EA 3539-40725. Again, the New York State code number is EA 3539-40725. So as we jump into candor obligations, I want to think of candor obligations very connected to the next topic of inethical conduct. So on the patent side, we know that this issue is very acute. We know that we have special duties to the USPTO. Right? We have Rule 56, Rule 1555, and we have other duties as well. We have the PTAB, duty of candor, but I want you to think, for you trademark lawyers in the audience, about 11.303 and 11.118. Sorry, 11.18. So when we look at candor issues, we think of ABA Model Rule 3.3. Thou shalt not lie to the court. And I want to reframe that for a moment. Thou shalt not lie to the USPTO because the USPTO thinks it's a court. So if you look at the definition of tribunal within the USPTO rules of professional conduct, it actually does include the USPTO. And that's because the USPTO says, we're not your opposing counsel. When you talk to a patent examiner, when you talk to a trademark examining attorney, they are not your friend. They are not your opposing party. They are not your opposing counsel. They are the judge or quasi-judicial officer. So when you are upset with the examiner or examining attorney that might have made a mistake or done something wrong, you're essentially upset with a judge, and you cannot share the feelings that you would with maybe opposing counsel. But it also means that you have duties to make sure, especially in an ex parte proceedings, which most proceedings for the USPTO are, that you're going to make sure that you do things correctly and accurately. It also means under 1118, which is based upon Federal Rules of Civil Procedure, Rule 11, that when you sign, file, or later advocate for something, you're doing so on information and belief after an inquiry that's reasonable under the circumstances. So when I sign my name on a document, I want to make sure it's correct. So, I'm in California right now, and I can tell that it's sunny and it's 59 degrees with a high of 77 where I'm at. If somebody calls me up today and says it's raining, I could say, dear client, it's sunny where I am. Could you please send me a picture? I could go look it up myself online to see if it's raining. But if I'm looking outside and it's sunny and somebody else is telling me it's raining, you may not think that's material, and it may not be material, but if my license or my reputation is on the line, I want to make sure it's accurate. And same thing for, the lawyers in the audience. Is it doesn't matter if this is a trademark application, patent application, PTAB or TTAB proceeding. You want to make sure that when your name is associated with the filing, that it's as accurate as possible. So how does it work with respect to your candor obligations in the trademark side? So when you file a trademark application, statement of use, things like that, it generally has what we call a verified statement. A verified statement under penalty of perjury that what you're submitting is true and correct, and that it, actually being used in commerce, et cetera. But you're also making that certification under 1118. So people say, do you have to fly out then to your client? So for example, you have a client in China, small company in China says, we want to file a trademark application. And now Emil is saying that, wow, we have to, make sure the information is true and correct. We have to fly to China just to file a trademark application. It's not what I'm saying. You have to have a reasonable basis to do so. So let's continue on with that hypothetical. That small company in China asks you to file a registration or trademark application for cell phones for a brand called Apple. It doesn't matter whether there's a specimen being submitted or whether it is intent to use. The question is, does it make sense to make that filing? Is it frivolous? What sort of analysis has been done? And what I like to say is, if it's not in writing, it never happened. If you sign that and file that Apple application, I want to see some sort of analysis written down. But in general, if you have experience with a client and they know what they're doing, you trust them, maybe you could do a little bit less work. But I want to see that you've reviewed the matter and then you've done some sort of analysis. You have a good faith basis. You check the specimen. Maybe you checked it on Amazon, something of that nature. But again, not in writing, never happened. If you come to me and say, I'm being investigated by OED because, you know, Amazon filed a grievance against me, which Amazon is one of the biggest filers of ethics grievances at the USPTO right now. So you say Amazon filed a grievance against me and they said that this was a bad filing. I'll say, well, show me what steps you took. And if you have no evidence, it makes my job much, much more difficult. And I'm not saying go spend 10 hours for an application that you're going to file in 1 hour. I'm saying have some sort of record saying, okay, well, here's my check sheet. I got this application from a client. They showed me the specimen. I already gave them a paper that shows the importance of a specimen. And then I went and checked the Amazon website and the Spotify store, and both appear to allow me to engage in adding the item to my cart. Shows like it looks like it's being used in commerce. So now jumping from the trademark side, let's go to the patent side. So we know that if we make a statement to the USPTO, we want to make sure it's based upon some sort of accurate statement, on information and belief or after verification, etc. But let's talk about ineffable conduct as it relates to that. So ineffable conduct has been called so many things. It's basically this idea of fraud against the USPTO. It's usually purported to a violation of a duty of disclosure obligation under Rule 56. And the biggest case that started this game was at the Supreme Court in 1944. And it was involving a company called Hazel Atlas. It was a patent application for making glass. I'm going to summarize it very briefly, but it's a really interesting case if you want to learn about ineffable conduct. It basically standed for the proposition that the application was rejected, and to overcome the rejection, the patent attorneys wrote an article that said, oh my God, this glassmaking process was so novel and unique. They then gave that article to an expert in that industry. That expert adopted the article and said, oh, thanks for writing it for me. And I don't know, changed it a little bit, published it under his name. And then the attorneys went and took that document that they had drafted or ghostwritten for that expert, submitted to the USPTO in support of patentability. The USPTO reversed itself and issued the patent. In some infringement litigation, a district court found no infringement, but the circuit court reversed, finding the patent valid and infringed. They had relied extensively on this expert's article. But then the infringer later learned about an issue with the authorship of the expert article. They filed a motion to vacate based on fraud. And ultimately, it was denied at the circuit court and reversed at the Supreme Court. And the Supreme Court said that this calls for nothing less than a complete denial of relief for the claimed infringement, thereby procured and enforced. And ultimately, they said it was a scheme to defraud not only the USPTO, but the Circuit Court of Appeals. And the USPTO's OED, which back then was called the Office of Enrollment and Disbarment, issued an order to show cause. And, basically it started this process of the modern day unclean hands / ineffable conduct. But this was a very, very unique time. Since that time, we've had an increase and kind of ebbs and flows of the allegations of ineffable conduct. And to the point where Judge Newman said the prevalence of accusations of ineffable conduct in patent cases have led judges to suspect that all scientists and knaves and all are knaves and all patent attorneys are jackals. That was back in 2003. And that was in a dissent that Judge Newman made in the Promega case. And I think about that a lot. I think about that, and I also think about what Judge Rader said about ineffable conduct. What he said was, it's the atomic bomb of patent law. And the court also said that the way this works is it infects everything. If your lawyer or an inventor or somebody associated with one application is accused of misconduct, obviously all the continuations or child applications are going to be infected. But sometimes it goes horizontally. Anything else that that lawyer or applicant inventor has worked on could be impacted. It really can infect things. And there's been a lot of changes to the understanding and application of inequitable conduct. And proving inequitable conduct is really two key elements, intent and materiality. And we know from the Theracense decision that in some ways it raised the bar and created a but-for, materiality standard. But since that time, has it really changed? And, there's a really interesting case called GS Cleantech, which I'll talk about in a few slides. But it has not gone away. It's still there. But before we get to GS Cleantech, I want to talk about another case. This is a Hatch-Waxman case called Belcher Pharma. And in this particular case, the court said that the most reasonable inference was that Mr. Rubin, who is not a patent attorney or inventor, had a specific intent to deceive the USPTO. And it was basically because they say he withheld disclosures from the USPTO when those disclosures were shared with the FDA. So essentially what happened was there was a journal article and two other prior formulations from another company of a similar drug, epinephrine. And evidence was shown at trial that the patent owner had told the FDA that the racemization of the drug, a consideration, was a well-known process. So you want to tell the FDA that because you want to say, hey, just pop this through. We just want this. It's normal, nothing new. It's just the regular drug. And then on the other side, you're telling the USPTO this is new and novel. So you're telling the FDA, oh, minor change, blah, blah, blah. But you're telling the USPTO, major issue, totally different. We need a patent. So you have two pretty contradictory statements. And the federal circuit here agreed with the district court and found this to be material to patentability because it would have potentially blocked the issuance of the patent. And in this particular instance, who is Mr. Rubin and why do I bring it up? Mr. Rubin was the chief science officer. Again, not a patent lawyer, wasn't even an inventor. But the reason I think that the folks in this audience need to be aware of this is because it's helpful for having a conversation with your client. Because I don't know if in this particular instance, Mr. Rubin's company would have sued their lawyers for doing anything wrong. I don't necessarily think a lawyer did anything wrong here, but it goes to that conversation. You're a fiduciary to your client. You should tell them, look at this case. When you ask me to stay in my lane and to just file a patent application, I'm happy to do that. But I want to know of those statements that you made to the FDA so I, as the patent lawyer, can make sure that we think about whether it needs to be disclosed. Because if not, Mr. Rubin can be accused of inequitable conduct. The applicant could have their portfolio wiped out, all because you didn't want to pay for a few extra hours of time with your patent lawyer. So what I tell people, the lesson here is you go back to your client, you tell them, I need more time. I need more, I need more information from you to be able to say, this is a solid patent and solid disclosure, solid IDSs, and that we're building the strongest portfolio possible. And it may mean it costs you a little bit more money, and it may mean there's a little bit more conversations with your product team, your marketing team, your other legal team, regulatory, but we want to make sure we get the strongest portfolio possible. So inequitable conduct, though, does impact a lot of lawyers. And the reason is because not only can you be in trouble for sanctions from the USPTO, from the district court, and obviously from the higher courts, but it generally leads to an investigation at OED. So whether it's an allegation of inequitable conduct or it's a finding of inequitable conduct, most people get investigated by OED. And it's very difficult. And I want to think about this for a second, and maybe the best way to do it is to think of a hypothetical. So a patent owner sues a technology company for infringement. The technology company alleges inequitable conduct by a patent owner, right? That's the affirmative defense. So you represented the patent owner. The district court ultimately finds ineffable conduct, and both patent owner and prosecution counsel, who that's you, want to mitigate losses by simply moving on. You're like, I didn't do anything wrong, but I want to move on. 2 months later, the OED investigation asks you about the district court finding and then requests privileged and confidential information. What can you disclose versus what should you disclose? Is the client the one complaining about you? Right? The patent owner is not complaining about you. And the state law, like wherever the court sits, do they trump the USPTO rules about disclosure of confidential information in response to an OED investigation? And then what if disclosing that information can further hurt your clients? These are really, really important considerations. But the lesson here in this hypothetical is that the prosecution counsel is not a party to this case. They're a witness. You're a witness in this case. You may want to try to convince the patent owner to fight because you're going to tell them, hey, I don't want my name strung through the mud. But how many times have I seen low-level, patent lawyers say, oh, we want to do a motion to intervene. District court's like, there's no legal basis to do so. You're not a party to this case. You might be a mandatory witness. I'm not going to let you in. If patent owner wants to use you as a defense, they're happy to do so as a sword, but whatever needs to be done. So it is really important to consider. And then OED will try to pressure you to give information, and you need counsel to determine what is considered privileged, what is considered confidential, and then decide what's appropriate to provide to the USPTO and whether or not state law may actually trump OED's requests for confidential information, like California law, etc. And I have a note here about clean files. Well, not a lot. It's a very small number of large boutiques in the patent arena that have this idea of clean files. And so you think about, what is clean files? So clean file is this idea, and I don't subscribe to it, by the way, that once a patent issues, we should destroy all evidence of communications with our clients in case we're ever asked to testify. And I think that's the wrong answer. Because, as I said earlier, if it's not in writing, it never happened. So when you're called to testify in a district court litigation and you're being asked to help prove that there was no intent to deceive the USPTO, when you have a note to file saying, client sent me this particular document and this is what I did with the document, that's very helpful. But if you've destroyed that, you have no proof. And therefore, it's your word against, what the allegations seem to show, which is, a story that you engaged in misconduct before the USPTO. So I want to go over the GS Cleantech case. The patents in suit here were directed to the recovery of oil from like a dry mill ethanol plant. It's like some byproduct called thin stillage. And essentially, there was a patent attorney that filed a provisional application and then filed a non-provisional application. So far, so good. He provided an opinion for them to swear behind. This is, again, pre-AIA. And then at some point, the case was transferred to Cantor Colburn, a well-known, prosecution boutique. And an investor sought some information, and Inventra had signed a document from July 2003. Interesting. Okay. So during the prosecution, we get a signed copy of that July 2003 offer. Then there was an IDS submitted saying that it was irrelevant because the method was never disclosed, carried out, or performed more than 1 year before the filing date. And if you remember, the filing of the non-provisional was 2005 and August 17, 2004 for the provisional. So this is very important because we're saying irrelevant. So we disclose it under our duty, but irrelevant. Then there's a declaration attaching a copy of the offer. It explained that the proposal was hand-delivered on August 18th, 2003. August 18th, 2003. So we would have been within the 1 year. And then the second declaration saying that the inventor had forgotten about sending the August 2003 email. Well, ultimately, all this confusion had an issue. They said that summary judgment of invalidity would be found because of an on-sale bar. And after the bench trial, the district court determined that the patents were unenforceable due to inequitable conduct, and the court determined that the inventors took affirmative steps to hide the July/August 2003 offers from their lawyers, and then later from the USPTO when they learned it would prevent them from profiting from these patents. So what does that mean? The inventors took affirmative steps to hide the offers from their lawyers. Well, that's not the end of it. The district court also concluded that Cantor Colburn purposely evaded it or failed to seek out the relevant information and participated in choosing advocacy over candor. It was ultimately affirmed by the Federal Circuit. We actually submitted a amicus brief in the Supreme Court, but that petition was denied. And ultimately, the judge actually passed away about a year after his order. So what could GS Cleantech or Cantor Colburn do? Well, obviously, GS Cleantech tried to file a petition for cert to try to get this reversed, but Cantor Colburn, not a party to the case. And you know what happened? GS Cleantech sued Cantor Colburn, deep pockets. And, I think the key argument, by the way, in the appellate issue was an abuse of discretion review that happened. So it was really more procedurally. But the ultimate issue also had to do with the way these issues don't allow the participation of the attorney, right? Because basically, the attorney is being said, oh, well, you chose advocacy over candor. You did not ask the right questions. You put your head in the sand. These are all kind of statements that were pulled out from different decisions in this case. And it's really important for us to consider, how do we move past this? Well, one, consider that clean file mentality. I don't think that's a great idea, but we want to think about our Rule 11 duties I talked about earlier. What is the inquiry that we did? So I'm not saying that you have to go again and depose your client to figure out whether or not there was an on-sale bar issue. But when there are these issues, maybe chart them out and say, if you provide this false information, this is what could happen. And imagine if you could show that to the judge and say, Judge, look, here's a chart that I made. Here's the warning I gave my client. There's no way that I would have done something incorrect, and there's no way my client would have done something incorrect, right? There was no intent to deceive the USPTO. Those are all important considerations. And of course, like that argument I gave you with flying to China, I'm not saying that you cannot rely upon what your client says, but it's a fact-based analysis. How sophisticated is your client? Is your client in-house counsel at a major company? Or are they the garage tinkerer that doesn't really know the words that you're talking about because they're not lawyers? It's really important to consider how that client interacts with you, what they know and what they don't know. Other rules, again, I got to talk about ethics rules because we want to get some ethics credit here. This is Rule 3.3 and the USPTO's version of the rules. And, we talked about it earlier. And it, basically says the same thing that the other ABA rules say, which is don't lie to the USPTO, don't hide information from the USPTO. That's fine. We can't make false statements of fact or law. We must correct those that we previously made, and we must show adverse legal authority. And that duty depends if there's opposing counsel. It's slightly different than from the ABA rule. And of course, don't offer false evidence. And maybe this is similar to what happened with Cantor Colburn. They were alleged to have provided false evidence. But what about the kind of different sections of the rule? So B here is not common. We generally don't have knowledge that somebody's going to be engaging in criminal or fraudulent conduct. But C indicates that your 11.303 obligation trumps your 1.6 obligation. It says the duties in paragraph A, which we talked about, and then of course B, continue to the conclusion of the proceeding. When is the proceeding concluded? In a patent or trademark application, potentially once it issues. But it says these obligations apply even if disclosure of information is otherwise protected by 11.106, which is the confidentiality rule. And again, it's a very, very complex analysis. I know it seems very clear here. It is not. D is really what applies to ex parte examination proceedings. In most people's instances, like a litigator is going to say, well, I'm never ex parte. At the USPTO, prosecutors that prosecute applications for the USPTO are continuously ex parte. So very, very important. And then, of course, E is a USPTO specific paragraph. It requires disclosure to comply with Rule 56, Rule 1.555, 1.740, 1.765, and 1.933. And, generally speaking, MPEP Chapter 2000, you shall disclose to the office information necessarily to comply with those duty of disclosure provisions. And I know we have about 15 minutes left. I'm going to try to get through our conflicts discussion. So I teach conflicts a lot, and I use this slide to really explain these things very simplistically. Conflicts are everywhere, and clients will usually sign waivers, and a waiver requires informed consent. If you can memorize those three things, I think you will understand conflicts a lot better. Of course, why are conflicts problematic? Because you can get in trouble, get in ethics trouble, get sued for malpractice, be DQ'd, and just build a bad reputation. But it's really important to think about this from an approach that clients will often sign waivers. Don't be scared of those things. But I want to connect the conflicts issue to our duty of disclosure issue for a second. Judge Newman, in a concurring opinion, said that a representation of two parties with conflicting interests does not allow you to deceive the USPTO, because we still have a Rule 56 obligation. So, when you're representing Lemelson and Smith in this case, and they have they have a technology that you may want to disclose in each other's applications, that's a potential Rule 1.6 issue, a conflict of interest. But if you cannot comply with that duty of disclosure, Judge Newman's telling us something. You have to withdraw. So just think about that for a second. It appeared to violate confidentiality to comply with 3.3 in Rule 56, but withdrawal is an option. Maybe not a financially great option, but it seems to be a good option. In terms of different types of conflicts, I think it's helpful for you to understand in patent and trademark law, unlike litigation, we don't generally have direct adversity. Instead, we generally have material limitation conflicts, that your responsibilities to another client, a third person, or personal interest would materially limit another client. And, specifically, we want to make sure that we deal with those conflicts before they become a conflict or as soon as they come to our attention. Right? Clients want loyalty, they want confidentiality. So a lot of people say, oh, well, is it a conflict of interest if I represent two people in similar applications? Well, just having economic competitors, not a conflict. However, if you have two people that are filing applications in the same technology area, think about confidentiality. Going back to that Mullins case, the Textron case, we have information that could be material to patentability that we might have to give to the other side or to the USPTO. That could be a violation of confidentiality, but also loyalty. What if we're using trade secret information against our client's own interests? Those are all very, very important considerations. And conflicts matter because they could cause a lot of harm. We're fiduciaries to our clients. We want to make sure we don't have an ethics violation, whether at OED or at State Bar. We don't want to get sued for malpractice and lose our insurance. We don't want to get DQ'd. We don't want to have our fees taken away. And, we want to make sure that clients can rely upon us and trust us. And an example of fee disgorgement and disqualification, all those things can be summed up in a non-patent case. This Shepard-Mullen case from, I think it was from 2018, it's a California Supreme Court case that actual harm is not required for fee disgorgement. So a firm was representing, client A, it was like a city on and off, and didn't disclose that to client B. When that client B found out about it, they decided not to pay their fees. Then Shepard-Mullen initiated an arbitration against them. And then ultimately they appealed in court, and the Supreme Court took it up and basically said, The arbitration provision in the fee agreement is not valid because the fee agreement is invalid. It's invalid because of the conflict of interest. Even though there was an advance waiver, the advance waiver could not disclose the conflict. And I want you to think about this for a second. If we go back to my slide that I asked you to memorize, a waiver requires informed consent. Informed. So when you come to me and say, Emil, what are you talking about? Why is it that there was no disclosure? Because an advance waiver that just says you waive all conflicts does not provide the client with enough information about what the conflict is. So I'm not saying that all advance waivers are appropriate, but an advance waiver that does not provide any information is not informed. So think about that for a moment. So how do I put this in a linear fashion? I like to say, especially for current client issues, I look at who the clients are, potentially what the issues are. And then we're going to do under 107A, is there a conflict? If so, is it direct adversity, material limitation, or subject matter conflicts, which is kind of a subset of material limitation. Generally not direct adversity. It's either material limitation or that subset of subject matter conflicts. So if it is, can we waive the conflict? We have to make sure we hit 107B 1, 2, 3, and 4. I like to start with the easy ones. Not prohibited by law. Generally, yes. Does not involve the assertion of a claim by one against the other. Generally, yes. Then third one is technically paragraph 1. Do you have a reasonable belief that you can accomplish this? I think generally, yes. When do I say that it might not be okay? If, for example, you're a sole practitioner and you're representing two people that are directly competing against each other, trying to literally get a same application be filed around the same time, and it's going to be really difficult to set an ethical screen in your mind. But the most important one, getting informed consent from each client confirmed in writing. And just a reminder about the rule, getting things in writing does not require it to be signed. It just needs to be confirmed in writing. So, dear client, just wanted to have a quick call with you to tell you that, we have this conflict and here's the pros and cons, is a great informed consent. And just following up in an email saying, dear client, as we discussed, thank you for the approval for the conflict involving such and such, right? A couple sentences in an email would be fine. They don't even need to respond. It just needs to be confirmed in writing. All right, so just want to go over a quick conversation about AI. And I'm going to start by saying, how many of you remember maybe 15 years ago, if you told your client or another attorney, I use Gmail for work, they would have said, you're violating the ethics rules because Gmail or Google or whatever reads your email to target ads to you. Or it's in the cloud and the cloud is insecure, right? Do you remember when none of us knew what the cloud meant? Now, how many of us are using Clio, Practice Panther, LawPay, Office 365, Adobe, all those things? DocuSign. Those are all cloud-based solutions where it's all the information is stored off premises, which in some ways is more secure. If a law firm called me and said, we have an on-premise Exchange server hosting our email, I would say that's a pretty big risk because your internet goes down, your email goes down. You have to pay to secure that server from attack. So how do we deal with AI today? I think AI today is the same thing that cloud-based service providers were 15 years ago. I'm not going to say that AI is going to take over the world. I don't know. But what I'm going to say is today, we have to treat AI with those same kids' gloves. We want to make sure we understand the technology. We want to do some sort of due diligence. Today, when you hire Microsoft to do your Office 365, you don't need to, spend 5 days, interviewing them for security purposes. I'm not saying you need to do the same thing here, but you want to have a conversation. Again, paper your file before you use the technology. Ask the right questions. How is the information going to be stored? What's going to happen with it? Who owns the information? Those are all very, very important considerations. as you determine whether or not you want to use AI in your practice. Another really important consideration is, did your client consent to the use? I'm not saying that it is required, but if we think about how cloud-based services were used previously, the idea was you were supposed to ask your client before using cloud-based services, 15 years ago. According to the ABA, their ethics opinion does state that you want to make sure that you get some sort of client consent to use AI. I don't necessarily think it's important to always get it, just depending on the circumstances, but it is unclear currently. Many states have different opinions on it. And it's something that's still a nascent technology, so it doesn't hurt to try to get that permission whenever possible. So what about the USPTO's thoughts about AI? So the USPTO has basically said AI is permissible and in some ways encouraged. The most important thing, I'm not going to talk about inventorship or anything like that. I'm going to talk about the director's memo from February 6, 2024. So over a year ago, the USPTO basically said the USPTO rules of professional conduct as currently in place cover the use of AI. So they're saying there's no extra ethics rules needed. 37 CFR 1118, which is that rule 11, still applies. So if you're going to use AI, make sure to review it, make sure you understand it, and make sure it is in fact secure. Because, and one very important issue that I was nervous about before that memo came out was Rule 56. So if I have information that I've gathered even through a Google search, that information could be material to patentability, and I might have to submit it to the USPTO. So the question was, if I pull information from a large language model, does all that knowledge that the LLM has underneath it, does that get imputed to me? And then do I have to impute it or provide it to the USPTO? And the director's memo said, no, all that information is not imputed because only the human being, only persons associated with the prep and process of an application have a duty of disclosure. So very important. How do I see the use of AI by patent lawyers? I have spent so much time reviewing and analyzing and working with some of these companies and written a lot of documentation about them. I've seen really, really good uses of analyzing specimens, making sure they're not fake, right? That's something that's really been used a lot lately. Predictive analytics about refusals. They'll even tell you which art unit they think that your application is going to be. Even a company that's currently trying to analyze potential subject matter conflicts of interest ahead of time. Amazing. I wish I had that, mindset to be able to get this done, but some of these companies are just really amazing in terms of what they're trying to do. So with that, I'm happy to open up to any questions, but while waiting for any questions, I'm going to do another quick hypo. This is a real life situation that I see all the time. And it's, a company from China solicits, they call it cooperation agreements. Basically, they're trying to give you referrals. Again, agency, et cetera, they're saying they're a foreign associate, which we already talked about. And they're saying you can just review the draft of the application. You can sign through T's or authorize an agent to sign on your behalf, collect the payments, and rarely, if ever, you communicate with the applicant. There's so many things to issue spot here. The main one that I haven't really talked about here is allowing somebody else to sign your name. When you sign or file something that bears your name or another person's name, you got to make sure that that was signed by the appropriate party. 37 CFR 1.4 says that on the patent side, you have to sign everything yourself, and 37 CFR 2.193 on the trademark side says you have to sign things yourself. So I will pause for a second and just say that foreign associates are permitted to do many of these things, like communicate with clients, et cetera. And as I mentioned, there's that official Gazette notice. But I want to think about this. If another lawyer in your community calls you and says, hey, file these trademark applications for us without talking to our clients, is that okay? Probably not, right? This foreign associate thing is a special permission that's given. Otherwise, you can't just file applications, can't ghost write for people, really, right? That's not something that we generally do in the US. And again, a lot of people probably will say, well, I wouldn't do that for Chinese companies. Well, if a British law firm reached out and asked you to do this, would you do it without talking to the client? And I think the answer is yes. It's a very common practice. I think recently there's been a lot of statements that saying, oh, well, we can't do this for China. We can do this for, other countries. You know, I think we tend to buy a lot of products that are sold by sellers on different platforms, including Amazon. And Amazon requires you to have a trademark application pending in order to get Amazon brand registry. And I want to be respectful of your time. I will stay on for a few moments if anyone has any questions, but it's been a pleasure. Thank you so much. And feel free to connect with me by email or on LinkedIn.